going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. All right, I've got a Judge Simpson clip for you. It is a landlord-tenant case, and it is part 2 of the landlord who broke into their tenant's apartment. In part 1, Judge Simpson had a lot of things to say to the landlord, so he scheduled a hearing so he could hear what exactly happened. This is that hearing. I will have the link to part 1 in the description. Please check that out before you watch this so you understand what's going on. Okay, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Well, I've had an opportunity to speak with Ms. Sanders.
I need you to state your name first.
Oh, yeah, that'd be great. William Gross here on behalf of plaintiff.
All right, go ahead. And your name?
Melanie Sanders.
Thank you. Go ahead now.
Thank you, Your Honor. The parties have been able to confer, and we're in agreement on a move-out date. And so at this time, I believe we're ready to enter a conditional dismissal in this matter.
All right. That what was raised this was entering the property without permission.
Yes.
Has that issue been resolved?
No, that's a whole different process that I'm still following through outside of this current issue.
We've certainly
I
discussed it.
don't. Go ahead.
We've certainly discussed it, and I think from my client's perspective, there was a misunderstanding of her ability to go back there, of the timing of the
To
eviction
go
process.
back where?
To the property where Ms. Sanders was residing. My client misunderstood the notice to quit date that was sent. She thought that was the move out date. She misunderstood her advice from counsel. So she appeared there that day and waited for police to arrive because she thought that was the move out date, but it was not. And once I found out she was there, I advised her to leave the property. And anyways, that was a misunderstanding on her part, but
She did sit there for 4 hours, she said.
right. Yes. Before. Yeah.
So it's the fact that I sent her a text stating I would not be home to leave the eviction notice on the door like you're supposed to. And she did not. She released my cats from the inside of my house and left the house window open, allowing property of my 10-year-old autistic child who is supposed to be homeschooled, computer and other belongings of his to be misplaced while I was away at work.
Okay, so.
I agreed to the move
And
out.
maybe, no, I understand that. I guess what I'm trying to figure out is, you said to me you're doing something else.
Yes, so when I talked to one of the police officers, they said to follow through with this part of it, of the notice to quit, to then bring up the charges of the attempted, I guess, alleged B&E that has occurred due to the negligence of them following through their lawyers' recommendations. Because
Is it still considered attempted B&E when it was admitted on the record? I don't think it really is alleged at that point. They admitted it. They broke in. And it's funny how they changed their story now. This is all on the record. The story was the landlord was concerned because there was a note on the door. So the landlord's sister broke into the apartment after waiting for the cops. They called the cops to do a welfare check. Now all of a sudden the story is they were confused on the move out day. I mean, that might have been why they went there, but they still had no business breaking into the apartment. All right, let's go.
they are at the,
Okay, I get you. So, okay, so here's my, go ahead, I'm sorry, ma'am.
because the plaintiff has repetitively told me that they have not removed things from the house. I cannot necessarily say that it was them, but because of their actions of leaving my home open,
Right.
that is the part that
Okay,
I have to.
so here's, I guess, my concern, and one of the reasons this was set for today is that you raised that issue
Yes.
of which I guess I want to make it clear, and I understand what you're saying with regard to what the police may have told you. You also may have certain civil remedies that are available to you, particularly if there is a claim, and I'm not saying whether it's true or not, that there was property that was lost. So and again, I'm going based upon what you guys are saying to me. Sounds to me like there's this move out date. It's just part of the COD, and that you are not going to pursue the civil remedies.
Oh, I'm pressing charges. That or for
Okay.
for that part of it, yes.
Right. And but understand, ma'am, what I don't want, just in fairness, is I don't want a circumstance where you've gone into this, you've entered into this agreement to dismiss the case, knowing that you potentially have these civil claims. When you then raise the civil claims, and I'm not saying that counsel's trying to anything untoward, I'm not saying that, but then you run into what could be an issue of potentially, I guess, race judicata or something where you had the ability to raise the claims and did not. And that implicitly, if anything else, those issues were resolved with the conditional dismissal, and therefore you wouldn't have a claim. You follow me? I said a lot of legal stuff.
If I may, Your Honor.
Yes.
I'd be glad to write into the terms of the dismissal that this does not dismiss any civil claims, arising from
Can I ask? Okay, yeah, no, I get
personal property.
Can I ask why that's not being resolved now?
I believe there's just a disagreement about
It's
the
just
facts.
Well, that's why we're here. We hold trials.
I have a whole empty house, not whole empty house, but I have very valuable things. School computer. My child is not in his online schooling because it is missing. Those kinds of things, Miss Branham has refused basically to talk to me about because she didn't break into my house.
Okay.
So.
Okay. Have you talked to or tried to get an attorney to advise you?
I did reach out, to the legal aid, they, sent me.
They're right there sitting next to you, so be careful what you say.
I did, they sent me over, a list of different lawyers that might help. My issue is that I mostly can't afford a $65 call fee right now.
No, I get you.
Yeah.
So did you contact University of Michigan?
I did not contact University of Michigan. I did contact the Hawk program. I was turned away because within all of this happening, they said because my son has a roof over his head and we're not in a tent, it doesn't matter where
You can't in terms of moving.
Yeah.
I get that. Okay, again, I don't mean to blow up this deal or anything. I mean, it may be the right call, but you're agreeing to move out because
So the homestead that I built with Travis, it makes me sad to just come home and.
all right, just hold on.
All right. So oh wow, that was a delayed pause. Okay, so she's already essentially moved out. She just needs to go get her stuff. But Judge Simpson, he's saying the right things. He's nervous about her accepting this deal that could potentially hurt her in her civil case. And this is why she needs an attorney, because yeah, they could, go to wherever she presses charges or in front of a civil judge, and the judge is like, "Oh, you signed this, so we can't do anything about it." That's what Judge Simpson's worried about, and that's why that attorney said, I'll put words in the dismissal to allow her to still, file her civil case. And like, this shouldn't be a landlord tenant case anymore, in my opinion. She's gone. Just let her get her stuff and be done with it, and then file the civil case. In my opinion.
Okay, here's the way we're gonna do this. You okay?
Yeah.
Hold on, just do me a favor. All right, just hold on.
Just real quick for what's going on right now. In part one, I don't remember who Trevor was to her. I think it was a significant other, but he has passed away, and that's where they live together. So I believe that's why she's emotional right now.
Before you start talking, do me a favor, take a deep breath, and then, well, even before you say anything, let me tell you what I'm going to do. Court rules would provide that with a conditional order dismissal, the court has to approve that COD. The court also has to be assured that the parties intend to enter into that and that they understand what that means. As laid out with counsel, I think she understood that portion. I think even with the additional language, she would understand that portion, that she could pursue something. I'm not sure, though, that there's a full understanding of what rights she can assert in this case. And so while you guys did your best efforts, I appreciate you working it out, this court will not approve the conditional order dismissal. So the question becomes where we go from here. And what I'm going to do is I'm going to adjourn this out. We will give you, I'm short staffed today, but I've got Miss Dendrinos and Miss Bauer sitting there. Could you give her the University of Michigan clinic's number for me, please?
We can also talk about the walking clinic.
Pardon?
We can also advise her about our walking, John. Yes.
You're going to advise her too?
About the walking clinic?
About the walk-in clinic?
Is it possible for Ms. Sanders to meet with anyone now and be apprised of her rights and see if she still wants to proceed?
We have to do an intake.
They have to do an intake, and I don't know. I'm going to do it this way because I don't. And counsel, I want to be clear. I'm not saying it's anything you're doing. I think it's people can feel pressured that they need to do something and they may not have to. It may turn out that the same thing that you guys are trying to do today happens, but I have a feeling that she may not have been apprised of everything, which would not be your obligation.
That happens at the initial hearing.
Pardon?
That happens at the initial hearing, correct? Like the tenant
Apprised of their rights?
Yeah.
Well, it does in terms of certain things, but also in terms of with this particular case, when it came up, the defendant raised the issue of entry into the premises without permission.
Sure.
And then that's when I set the final settlement conference. I adjourned it out from, well, no, I didn't adjourn it out. I set it for today. From that statement. I get here today, I understand what everybody's attempting to try to do. The court's just not going to enter it. because I don't think that this defendant understands and appreciates that while she may have and again, I'm not saying she does, but that she may have criminal recourse in this. I don't think she understands that there may be civil recourse that she has. And so if I don't think a defendant fully understands what their rights are, what they can do, whether they choose to exercise it or not, I'm not entering the order. So it's not going to happen. It's bottom line. So how much?
All right. I'm glad he said it that way because that makes a lot more sense. Now I'm a little less skeptical of Judge Simpson kind of coaching her from the bench. So makes a lot more sense where he's afraid that she doesn't understand her rights and what she can potentially do. That makes more sense. So I withdraw my previous statement. I don't think I said it the way that it was in my head. I think I was a little bit more careful with my words, but that's what I meant. And you guys probably saw through my charade of fake words. All right, let's finish this up.
Time, what I will do is, what dates do I have?
I'm sorry, September 24th or October 1st at 9 a.m.
All right. What was the plan to move out date?
September 30th.
Okay. So let's do this. I think, oh goodness, Bauer, what do you want now?
Your
No.
Honor, you know, the clinic is closed on Thursday this week. So she may need a little extra time and it's going on.
Bauer doesn't think I read emails. Miss Lee sent out a wonderful email apprising, no, just listen. She sent out a wonderful email that I actually read because when it comes to Tish, I read it. So I read the email indicating it was closed. Then I was at a meeting Wednesday and they also told me that, but I already knew.
But I wasn't on those emails, so I didn't know all of that happened.
You just didn't think I knew what I was doing. All right. Thank you, Ms. Bauer. Here's what we'll do. We have the 30th, you said, 24th.
The 24th.
I'll adjourn this out to the 24th. September 24th. Will that work for you, Council?
What time?
That'd be at 9 a.m. I'll just keep it on my final settlement docket at this point.
That's fine, Your Honor.
All right, that'd be before what was anticipated and see where we can go. So that gives you 2 weeks to do that.
Get my life in order a little bit.
What?
So to get my life in order a little bit more.
You can get your life in order in 2 weeks? Because I'm having a problem and it's been
Actually,
years.
Pretty efficient.
Yeah, okay.
I'm pretty good at the rising after some crazy stuff, so.
Okay. All right, so we'll see you guys on the 24th. They'll give you information regarding walk-in, also University of Michigan, see where we go from there.
Thank
Okay,
you.
thank you.
All right, that's it. Remember, if you haven't seen part 1 yet, and this didn't make a lot of sense to you, the link is in the description. Go check out part 1. But yeah, that's all I have. I will be going live this afternoon. I've got a pro se jury trial that I want to show you. And it's a long one, so it's probably going to have to be in 2 parts. And I don't like doing that, but I don't want to be live for 3 hours. And it's about 3 hours. I'm going to see how far I can cut it down between now and 2 o'clock when I go live. So we'll see. We'll see. All right. You guys have a great rest of your day. If you haven't done it already, please hit that like button. It does help out the channel. And until next time, bye.